In the know.
Good evening, everyone.
In the know.
Tony Reeves. Tony Reeves.
Fire. Following the news in any way, shape, or form.
No shortage of things to talk about.
What does it mean? What will it bring? Is this a reality we simply have to accept?
Tony Reeves.
Fire.
Tony Reeves. Let's go ahead and get
Welcome
started.
to part 9 of our step-by-step guide to understanding your disability hearing notice. Now, the final portion in here is, usually it says the decision. If you notice, it's like a paragraph talking about, oh, you'll get the decision in the mail, but here's what you need to realize. Sometimes at a hearing, the judge might tell you which way they're going, but they probably won't. So don't get upset or frustrated if you walk out the hearing and after waiting all this time and nobody tells you anything. Just note in the grander scheme of things that you're going to get a written decision. The written decision is going to come to you in the mail, and if you're a representative, they should get a copy of this as well. So for those of you who are probably trying to figure out, well, then why are you bothering for the hearing? Trust me when I tell you, they're putting you on notice so that when you get to the hearing, you're not expecting kind of like a Law and Order thing where the judge sits there and hits a gavel and tells you what their decision is going to be right there and then. You may walk out that door and not have a clue which way they've gone. So just know in advance that there's a good possibility that you won't get anything until you get a written decision from the court. Okay? Now, don't go anywhere. When we get back, I'll talk to you a little bit about why those written decisions are important.
Under the Social Security regulations, representatives are permitted to practice before the administrative agency anywhere in the country, which means that when you're looking for a representative, you can find someone who doesn't necessarily have to be in your state if you're just going before the administrative agency. So it's possible to have an attorney or representative who's from Utah, even though you may be in Georgia. And our office is actually no different. So if you're wondering which states we cover, check this out. Now, the tricky part is once you have to sue the Social Security Administration. Under that situation, you want to have an attorney that's representing you in your jurisdiction. So if you have a representative who's in another state and you've gone all the way to the Appeals Council and you've been denied and you want to sue the Social Security Administration, make sure you ask that representative whether or not they can sue someone in that particular state.
Okay. I know you probably want to be told there and you want to feel good about your case and you're anxious. You want to hear about it. Let me tell you something. You want the written decision. Why? Well, that is the document Social Security needs and relies upon to ensure that you get paid if you get approved. It gives information about how far back it goes, if there's any issues related to workers' comp that has to be addressed, work representative payee, or continuing disability review, all those things. So you want the written decision for that particular purpose. It's necessary for when you get paid, in order for you to get paid. If you get denied, you need to know the specific reasons that the court relied upon in making the determination that you are not disabled, so that if you want to challenge them, you will know exactly what you're challenging. So in essence, you need it in order to get paid. You need a written decision in order to get paid. You need a written decision in order to appeal. Let me tell you something that you may not have noticed in here. It doesn't tell you when you're going to get the decision. Now, let me just tell you in advance. You're going to go into the hearing, and you might get a judge that tells you, kind of in a laid-back way, oh, we'll probably get this thing out to you in about 30 or 60 days. Do not hang your hat on that date. Because if there's something weird going on, if there's a backlog, if they're having a slowdown to write decisions, 60 days could come and go and you'll be around that thing mad as all get out. Don't get frustrated. That's the reason why they don't tell you time in there, because the reality is they don't know exactly when it's going to come out. Now, am I saying it could take a year long? No. Let me just say this, because I know I have colleagues in jurisdictions with judges who have taken that long. So it's not uncommon. It's unnecessary, unfortunately, but it's not totally uncommon. If you got a representative, ask your representative what's their experience with that particular judge in terms of length of time for a written decision. But just keep in mind, it is once you walk out that hearing, You won't get a decision until it's in writing, and there's nothing in the notice that's going to tell you exactly when you're going to get that hearing decision. All right, everybody. Hope that was good for you. Come back here tomorrow, and we will talk about part 10 of our 14 parts step-by-step guide to understanding your disability hearing notice.
I want to thank all of you for engaging in the videos. Make sure you take the opportunity to send me any comments or send me any particular questions that you want me to have addressed here. As you know, this show is for you, and so the only way I can make sure that I can provide you some good information is if you provide me some good questions. Keep them coming, and right here on Q&A, Social Security Disability Today.